Yeah. Welcome, folks. This is Joint Justice Oversight. It is October 27th. It's a morning scheduled meeting, and we're going to start off this morning with Jay Johnson, General Counsel from the Governor's Office, to give us a walkthrough, answer questions about the new contract that the administration signed with the U.S. Marshals, as well as conversations on the new contract or memorandum of understanding, however it's going to be termed, with U.S. Customs and Border Patrol in terms of housing federal detainees for criminal activity, as well as housing codes for ICE. We did get a copy at our last meeting of the new federal marshals contract, and we did get a copy of the updated MOU. And then our legal counsel, Ben Novobrowski, did do a summary of both of those that was sent to us and is posted on our committee webpage. So Jay, I'm going to turn it over to you. It was the executive branch, the fifth floor, that negotiated both of these. And we wanted to give you time before us to explain both of them and answer questions that we might.
Sure. Thank you, Chair. Thank you for having me in today. My name is Jay Pershing Johnson. I'm Governor Scott's legal counsel. I actually was not aware that I was going to have to walk through the two agreements. So I don't know if you have copies. I am happy to walk through them.
If you could give a summary in terms of what was negotiated and how is it different,
Sure.
how it's going to play out.
Sure. And just to clarify, I did not negotiate those contracts. They were not negotiated by the fifth floor. They were negotiated by DOC. To the extent that I think they are identical to past agreements. The Border Patrol MOU, which is often referred to as the ICE contract, is not an ICE contract. It is an MOU with Border Patrol that was changed in 2025 from, I think, the 2024 version to be identical except for contact information, financial responsibilities, which includes an escalation clause for the per diems. And there is no specific termination date. It's like in the prior one, it was a date certain in August or November, September, I think it turned out to be, because it's the date that the last person signs the agreement. And they took that out, and it is terminable by either party with notice. So those are the only differences. That was signed in September. Oh no, that was signed, yes, in September. Yeah, so that's the MOU with Border Patrol. I believe the information that I have from DOC is what largely happens with that contract is they're undocumented individuals who are picked up by Border Patrol at the northern border and transported to DOC facilities. That's the arrangement. We are reimbursed for those costs. They stay, I think in say 2023, it was maybe 3 days. Now I think the average time is longer, somewhere 5 to 7 days. I think many of the same operational problems that existed in 2023 when they were reported to the legislature exist today. But I do think that we actually have some flexibility in that agreement to actually control those situations if we were to actually work with the federal government and enforce the terms of the agreement. Subject to the policies of the state. There are specific terms in there about the facility being accessible to Border Patrol during business hours. We are not obligated to take people if we don't have capacity. And I think if we have operational concerns, there's flexibility in that agreement to address those. So that's the MOU. Do you have any questions for me?
Got a couple. So I just want some clarity. So for the MOU, it is for folks that the Border Patrol picks up at the border, that are folks who are undocumented. And they are the ones that are held. It's not folks that are picked up through ICE and come in and possibly be held at our state facility, but they're picked up from another state. Does the MOU cover that as well? Or not?
The MOU does not address that.
The MOU only addresses Border Patrol picking up folks at the.
It doesn't
border that
say.
are
So I just want to be clear. Typically, that is what happens. The MOU does not address which individuals are picked up under what circumstances and then brought to the DOC facilities.
So it could be
They just are undocumented individuals in the custody of Border Patrol. They're brought to the DOC facility for a brief period and then transported to another facility for a hearing in immigration court.
Oh, this is where it gets confusing. So what if folks, does this MOU cover folks from ICE who are picked up?
I believe they're transferred to Border Patrol custody. It would not prohibit that, but we wouldn't have visibility into that. And I can't answer that question. Maybe DOC can.
Yeah, so that. So you were, I'm just trying to go through the time frame of this change in leadership that occurred. So you were saying the DOC is the one that negotiated the new MOU,
Yes.
not the fifth floor.
Correct.
Was it the previous commissioner or was it the current?
I think it was during the changeover. I believe that it was negotiated by the deputy commissioner. And she was constant.
So we sent a letter dated August 1st to the fifth floor.
Mm-hmm.
Was that, came from this committee and it had 5 things that were addressed. Do you know if that letter was forwarded to DOC saying, because we were told that DOC is not doing the negotiations, it's the fifth floor that was doing the negotiations.
That's what DOC told us.
That's what DOC. So we sent the letter to the fifth floor. Do you recall receiving the letter?
I do recall receiving the letter.
Was it forwarded to DOC?
It might be CC'd to DOC. I believe DOC had the letter.
Commissioner Mira, did you want to weigh in terms?
And Chair, I think I could clarify perhaps. The agencies often bring issues to the fifth floor, right? They'll say, this is if it's extremely sort of in the media, if it's political, if it's, there are obviously lots of considerations these days. The legislature had expressed concerns with a number of political issues and policy issues during the session and after the session. And so a lot of those things get flagged by the governor's office, right? The governor is obviously interested in operational matters as well as policy matters. And so a lot of those things are flagged for the fifth floor. The agencies often say things like, we're waiting for, we can't do this without permission from the fifth floor, like things like that, right? I mean, so that in some ways is not accurate because the agencies obviously have pretty broad agency discretion in their own individual statutory schemes. But when the governor is obviously the chief executive officer of the state, and a lot of matters are brought to the governor, this governor, as everyone should, I think, realize by now, is pretty hands-on. He receives a weekly report every week from every agency, and he reads it cover to cover. He wants to know what's happening across the enterprise and how do issues intersect across the enterprise. So like we'll talk about with Burlington, there are obviously AHS and DOC and public safety intersect across the enterprise on things like public safety. So this is, so of course these issues rise to the level of the governor's office. I can't personally, and the governor certainly can't personally negotiate every contract that the state enters into. So the agencies do that work. If they think we're interested, they'll tell us where the differences are, and we were certainly interested. So that's why I know, because I received a copy of the MOU and I understand the changes, and that there were 3 changes. We didn't object to any of those changes. There's a historic relationship, right? We have had this agreement across Democratic and Republican administrations. Border protection is a priority of the federal government and is important to the citizens of the state, being a border state. There's lots of activity at the border. We know there's lots of illegal activity, across the border, human trafficking, gun trafficking, drugs, matters of commerce, things like that. So Border Patrol has a legitimate role. They're there to protect the border. Whether you like it or not, that's their job, and it's federal law. So we have entered into this agreement to temporarily house detainees for decades now. So I think that I don't know what your specific concerns are. They seem to be, at this point, are you bringing people in from out of state to house them in our facilities? I don't know how much visibility we have into that, and the agreement does not specifically address it.
We have some questions. I'm going to hold off a little bit, so Jenny and then Teresa.
So thank you. Understood that this is a federal issue. We are in very different times right now, so that we're seeing a federal government that is somewhat more aggressive with some of the illegal or undocumented folks. And we've also seen some things that feel egregious, both to the courts and to people. So the concern about this contract is that we want to assure that folks who are coming into the state have their rights protected, for example, and looking at prisoner rights and programs. Do they have immediate access to legal counsel? Are the courts notified when someone comes in particular someone from out of state comes in and is housed in our state? Is there immediate access to defense counsel? The fact is that our concern isn't as much with who we are as a state, because we understand our values, but the concern that we have is that there has been a change with the values at the federal level, and that filters down to folks working in the U.S. Marshal's Office at Border Patrol. So from that perspective, can you help us understand what we're doing to ensure that people's rights are protected, that the housing that they have is appropriate, that people coming from out of state have some link with the foundation that they might have made in the other state, their families, their jobs, so we're kind of in the blind here in knowing what's happening there.
I appreciate that, Senator, and that's quite a list. There are certain things that we can probably address, and there are certain things that we have no knowledge of, right? I mean, that's just, so if you object to the existence of the agreement, I think that's an issue for you to discuss amongst yourselves. If you are asking, can we address all of those considerations in this agreement? We probably can't, and we don't. We do say, like I mentioned before, in the agreement, it is subject to all of DOC's policies and procedures. So they do receive adequate clothing, as far as I know. It definitely is specific in the Marshal's contract, but to the extent they're in DOC custody for roughly 5 to 7 days, the DOC will do what it can in that time frame. It will feed them, it will clothe them, it will provide them with medical care. If they need medical care that takes them out of the DOC facility and into a hospital, that will be paid for by the federal government. All of that is covered in the agreement. if you want me to be able to give you assurances that they were not separated from their families because they came through New Hampshire, I cannot give you that assurance, and that is not addressed in the agreement.
And so the issue is, what is the time frame within which they have access to legal representation? So it says here, the prisoner's rights, I see that the grievance programs, have access to legal materials and confidential communication with counsel and visitation. Does that happen on the first day, or does it happen the day that they leave? No, so it's just like, it's really critically important if someone leaves their home environment, whether it's here in Vermont or another state, then at what point?
So you're asking about whether they have access to counsel. That seems like the question. So it depends.
Within the time, what's the time frame within?
Right. So again, they're there maybe 7 days. There is recently, through nonprofit organizations who have expressed interest in providing this service pro bono, there is some arrangement, I believe, where people can access counsel. It may or may not happen within the 7-day timeframe based on the availability of counsel. They are not entitled to defense counsel because defense counsel is for state crimes, and then federal crimes are handled under federal defense counsel. So the federal law, and I am certainly not an expert in this, and you can find one, I'm sure, will tell you based on the kind of detention that it is, right? If you were here on a green card and charged with something like a violation of, I don't know, you're a threat to Homeland Security, your rights are going to be a whole lot different than the person who comes across the border and is undocumented and may or may not be here, may or may not be committing a civil offense under federal law or a criminal offense under federal law, because reentry is a criminal offense. So I guess you're not entitled to counsel under the federal system or under the state system, because that's just the way that it works. So like I said, we have received outreach from organizations interested in providing that counsel. But again, the timeframe that they're here in is very short. They're given materials. I believe the commissioner can speak more specifically to what exactly we are able to do at this point. But they have no more access to counsel. They're in terms of sort of, does counsel show up on site? Are there scheduled office hours? Is there someone on call 24/7? I don't believe that that's the case, and it's not feasible. So we may wish that, but it's just not feasible at this time, given the resources that we have.
So, and that's my last question. I think it's my last question. So when you mention resources, what resources does the federal government provide us to ensure that folks have access to legal representation? Certainly the federal government doesn't want to leave people out in the cold in terms of their ability to access counsel. So I see all of the dollars that are coming in for housing and food and medical care and so on. What, if any, funds or resources come to us from the federal government for purposes of legal representation?
Zero. There is no.
Has there ever been
federal fund?
Has the federal government ever provided any of that?
No.
So it's really, the federal government is prosecutorial.
It's not prosecutorial, right? I mean, they are going to be taken from our detention facility to an immigration court in a different state. We don't have an immigration court in Vermont. So they get taken to a different state, a different facility where they're detained and have access to immigration court in that state. They are just here temporarily so that they do get the treatment, the good treatment that Vermont will provide to them, but they are here on a very temporary basis.
Has Vermont ever asked to have resources for the legal protection for folks. I know there's obviously one example in our state where an individual was adjudicated in the state, that landed here and this became the place.
Mhm.
So have we received any compensation for that process? Is there a process for us getting compensation for the work that we do in terms of support? It just seems to me that it feels very broken, and then people's lives are becoming broken. We don't know how many folks are actually being picked up for good cause, and those that may have lesser good cause or no cause at all. So
They do end up in immigration court, right? And
Yeah.
sometimes, like you say, there are cases where they are documented and they are picked up for different reasons, and they do have access to federal court. And they access counsel. There is counsel that expresses interest and represents them. I mean, as you say, it is a different time. And that is probably the reason we have any council representation right now. There is, historically, the kind of interest that's being shown in this system has not been shown in this system, except to the extent that there are DOC impacts on operations. Now, because of the times we are in, people are interested in this, and for the first time interested in whether they get counsel and when they get counsel. This has been a system that is in place for years. So it used to be that when they came in and went out within 3 days, say under the Biden administration or under the Obama administration, they really didn't have the opportunity to obtain counsel at all because it was such a short turnaround time. Now they're in our facilities for a little bit longer, and they may or may not have access to counsel because we have groups that are interested in providing that counsel. So, I mean, because it is a different time, it is the first time that groups are really seriously interested in whether these individuals are getting representation. And I'm sure this will be an inflammatory remark, and somebody from legal aid and others will come in and say that's absolutely wrong. They've always been interested in it, but it has never been this kind of a public sort of, it has never risen to this level. I don't know, but I don't believe it's ever risen to this level in terms of interest.
Well, and certainly what you say is accurate but the concern is that some of the people who are being caught in the net are people who should not. And there's a difference of opinion there, I think, or a legal opinion there. So, but thank you.
Yeah, and to the extent you're saying individuals caught in the net wrongfully and they're brought to Vermont facilities, those individuals are going to have their day in court somewhere. And depending on whether they have documentation, they may end up in federal court in Vermont. They may end up in immigration court in New Hampshire or Massachusetts or New York. So we don't have any control once they have left our facility, but they do get due process. And again, I can't assure that because obviously in the early days, there were 200 people who were sent out of the country without it, but we have not seen that in the last, say, number of months. And we would expect that the administration will respect the courts in this regard.
We have another question, Teresa.
Thank you. My question actually relates to some testimony we heard from DOC a couple months back around the sort of additional internal resources this was taking in DOC because of, I'm presuming, the bit higher volume of folks. And so all the things that you said that, our DOC is doing, that's what they were testifying to. And I think one of the things that we wanted to be, raised in the negotiations was the extent to which we were going to get federal reimbursement for those, for that type of services that, DOC is already stretched in our facilities. I think that's pretty well documented. And so there was a sense from the testimony that was given that that this was additional pressure on that already difficult staffing issue. So just curious to what extent you feel like the agreement, the results of the negotiation help address that.
I think it would be in the escalation of the fee of the per diem payments. So before there was no escalation provision. If there had been, I think the current rate would be slightly higher. So I think now we have a higher current rate, and then that escalates automatically. I think 3% or 5%. It's in the agreement you have every year, so that we are assured of the higher rate. That's all I can really say in terms of how they are addressing our service needs and our need for reimbursement.
We have it on the memo from Ben.
Yeah. I guess that's better than not having it for sure.
Yeah, I mean, it's not like we can send them an invoice and say, and we have these extra costs, please pay it. That's not an option.
Right. I hear that. I guess I'm just trying to voice the concern of folks inside the facility that the strain that it's causing on our staff and corrections folks.
Right. And again, I think that is something that the legislature has largely been received reporting on in past years as well. 2023, under the Biden administration, I believe we had many of the same pressures and concerns. Numbers of individuals coming in at night, and that's a limited holding space. I think the biggest pressure, and again, the commissioner can speak to this, is the number of days is more problematic, because they used to come in and go out. And now it's, if 25 come in at a time and they're there for a week, and then, so it's that sort of compounds, I would imagine. I think that the commissioner again can speak to that, but I think that's an added pressure that we didn't necessarily have in earlier administrations. Mm-hmm.
So is there any, are we keeping track, and maybe this is, I don't know for whom that I am asking the question. But are we keeping track of any extra costs associated with the work that we're doing that go beyond the contract? So that at some point we can say, we need to balance our budget.
I think that is a DOC question. And I would say, to the extent that we might always say that reimbursement under the Marshal's contract and under the Border Patrol MOU is not sufficient, it still creates it still generates a significant chunk of money to offset the costs of DOC that we otherwise would not have and would have to pick up with general fund dollars.
But do we keep track of the overage at all?
I'm pretty sure that there's a sense of it costs us X and we're getting reimbursed Y. So I think, that basic math we would have. But again, I'd have to defer to DOC.
Sure.
So this might be a good segue to bring the commissioner up, because I also have a question in terms of the MOU, the medical services that Vermont is responsible
Do you want me to
for all medical care. It can stay there. It's still on the hot seat. Because we still have good. About federal marshal.
Yeah, right.
But in terms of the MOU, it's very clear in terms of medical services that Vermont is financially responsible for the medical care that's provided inside the facility to federal detainees. Is that putting a strain on our WellPath contract at all, Commissioner? If you could also just identify yourself.
Yes, I'm John Murad. I am the interim commissioner for the Vermont Department of Corrections. I want to note that I'm amazed by how much Jay knows about these. These were DOC negotiated contracts. We absolutely seek the governor's input on them and make certain that these are a negotiation that he wants to participate in, but it was, or at least wants to be apprised of, but this was negotiated by DOC. It was Deputy Commissioner Kristen Calver, just really working off existing MOUs that we had with these two entities. We did not have a GC at the time, and so we sought guidance both from counsel at the secretary's level for AHS and from Council Johnson. You did as well or better than I would have done as far as answering several of these questions. With regard to the question around WellPath, I think that anytime you bring people in who have a language barrier, it creates additional challenges for our healthcare providers. It creates additional challenges even at intake for our DOC employees. We have methods by which we have translation services accessible. We have posters and handouts that we can use to allow people who are coming into the facility to identify for themselves which language they need to use or would prefer. But if you're going to do a medical evaluation, which is a little bit more elaborate than, for example, the intake information that gets shared, I'm certain that there is an additional challenge when the person does not speak English. And many of these immigration detainees do not speak English, or their English is limited. So that is a difference. But otherwise, we bring in lots of folks who have medical needs. I think that overall, it is true that our population is more aged and more infirm than it has been overall for quite some time. That's a function of what we see with regard to lots of different factors out in the world, whether it's the opioid epidemic or whether it's just an aging population, which we all know we have here in Vermont, and the people who are detained are no exception to that and are just a statistical sampling of that. With regard to the folks who are being brought in as immigration detainees, they too may have certain medical needs or not. But I don't know that it's, these are people that are being brought in. It's a component of our expectations of how many people we're going to address in a given day.
So our WellPath contract, when we negotiated that a few years ago, we were not really holding as many federal detainees, and particularly we were not holding the numbers of ICE folks that we have since January or February of this year. So are there any indications that there is pressure on our WellPath contract, that what we've agreed to pay them is not covering the cost, and that we may need to augment the contract?
I have not heard that. I know that we are working out with WellPath our ability to deliver enhanced substance abuse treatment, to be able to deliver new kinds of treatment, but that is not specific to this immigration population. I have not heard that there has been either a desire to or a clamoring for renegotiation by WellPath itself.
Because I do.
I do have one quick question, Commissioner. In reference to, I keep hearing about the increase in undocumented population within our facilities. Do you have the information that would lead us from the past two previous administrations as to where we are today, what that increase may or may not be within the state of Vermont facilities?
I do not have it with me, but we do have that. We do have access to that, sure.
Because there seems to be some sort of conception that we've doubled our population with undocumented individuals here, and I just want to know what that number is what I'm looking for.
I don't know that it's doubling or not. I know that there has been an increase. I want to remind everyone this is a fractional component of our overall population. On any given morning, we may have 4 or 5 female detainees, and we may have 8 to 15 male detainees. That is a fractional number of the folks that we're actually housing in any given facility. And again, these are 2 specific facilities. This is in Northwest for the men, and it is in CRCF and Chittenden Regional Correctional Facility for the women. Although the contracts both allow the use of any facility if that's what's necessary at the moment. But that is where we are bringing in any number. But those numbers are small portions of the overall populations in both those facilities.
So if you can supply those numbers, I would like the hard numbers and not percentages, because percentages don't tell me anything. I want to know hard numbers. In fact, you have that opportunity.
Sure.
Thank you.
And what also might be helpful in addition to that would be the length of stay, because that's the testimony that we've heard as well. And we just heard today that the length of stay used to be 2 or 3 days at most, and now up to 7 days. So that's creating more disruption, possibly within our facilities. And also what we've heard in previous testimony from DOC, that the facility is not notified when federal folks come in to take the detainees and move them out. And that can happen at 2 o'clock, 3 o'clock in the morning. And they're taking out a number of folks and bringing in another number of folks, and it's really disruptive to our different areas. For that, so. Martin and then Jenny.
Yeah, just a follow-up question regarding the numbers. Just to be clear, if we could make sure that we have both, all federal detainees, but also broken down on which ones are coming from Marshal Service and which from ICE. So not just the ICE detainees.
Well, not just the border folks.
Not just the border folks, right? Yeah. So any federal detainees would be helpful to understand the numbers. The question I have is what is DOC doing to help accommodate getting legal counsel from, for instance, the asylum, Vermont Asylum Assistance Project or other providers, and what is being done?
We provide VAP with a list of the detainees each day.
And they are able to get into the facility to represent the individuals?
They have the same access as any attorney has to a person who's detained in one of our facilities.
Has there been any pushback from the Border Patrol or Marshal Service on your trying to accommodate bringing in legal counsel?
With regard to, for example, providing this list, no.
So, yeah, that's a good question regarding legal support. I think it's important, and welcome, Commissioner.
Thank you.
I haven't been here anything.
Yes.
The question on language is really important. And, we've taken this up in our committee a few times, and looking at access to software, for example, that provides translation, and particularly in the medical area, I'm talking here. So when folks are brought in by U.S. Marshals, or when they're arrested, there must be some background information about them in terms of their home country, whether it's in the African continent, or whether it was Latin American, Mexican, some language info there. Does the Marshal Service provide that information to folks at DOC, in particular the healthcare folks, so that they can get a jump start on helping them understand?
My understanding is that it's provided by the detainee or incarcerated person themselves, that he or she will, as I said, for example, point to a language on a card and be able to identify what language is going to be used individually. It's not necessarily something that comes with the paperwork from the federal government when the individuals are dropped off.
How do they communicate with these folks then? I mean, that's a little bit sad.
I think that I do think that, I mean, I've seen videos of people having language skills that they use.
Spanish is a little bit different from other more complex languages.
That's no different than situations that certainly policing runs into in any polyglot urban area. And there are tools available for that, usually language lines that are available for that. But how you determine what the person speaks can be challenging. My wife was at the hospital 2 weeks ago, and the person in the curtain next to us was speaking Haitian Creole. And listening to the hospital try to figure out what that was and then actually work with it was interesting. But these are challenges that we all deal with.
So thank you for that. I know it is a challenge, and I know it's complex. Understood.
So let's move to the federal marshals new contract, which I believe has been expanded to include ICE from the previous contracts. And it also includes the Bureau of Prison as well. So my first question, is that new to the federal marshal's contract?
It's my understanding that ICE has been sort of added to the marshal's contract through that checkbox since 2011. And I'm sure, I mean, there are contracts. We certainly could get copies if we needed to. And I hesitate to provide that assurance, but we should be able to.
So would you just address this, the federal marshal's contract? In my understanding and reading this, it only applies to the St. Albans facility.
It is an interesting contract because it has as a party, the St. Albans facility, which I'm not sure I would have drafted it like that, but that is the way that it, I guess, historically has been drafted. I'm assuming that's DOC because DOC signs it. But I would just say that it does seem limited to that facility. And I don't know it well enough in detail to go through whether that is more expansive in terms of where they can be located, but it's my understanding that it is just that facility.
And on the first front page,
Yes.
estimated number of federal beds is 80 males and 20 females. So that implies the Chittenden facility is used, unless you're holding the females up in St. Albans.
Right, that would suggest that.
And do those numbers, that 180 males and 20 females, does that include folks under ICE?
It does in that the ICE, in that immigration is a component of this contract, sort of a rider on it. I think in conversations with marshals, they've indicated that it's their belief that those are sort of ancillary and that number of 80 is for marshal detainees. And so should we, for example, one day have 15 ICE detainees and suddenly the marshals were to show up with 15 male ICE detainees and the marshals were suddenly to show up with 80 which is inaccurate because there are at any given time, there are other federal detainees in the system and they are not only at Northwest. So let's just for the sake of this argument say, however, that there are none other than these immigration detainees, 15 male immigration detainees, and suddenly the marshals in some sort of massive sweep of a kind that we've never seen before arrive with 80 detainees. The contract suggests that we would be beholden for taking all of those 80, irrespective of the 15. And at that moment, we would either find other ways of arranging for the 15 immigration detainees, or we would certainly refuse to take additional immigration detainees, which we have done at both facilities. We have said, nope, we're too full at this moment. We don't have the capacity for this at this moment. The superintendent at Northwest has said no to incoming numbers of immigration detainees on occasions.
So with a cap on the federal marshals, and those federal marshal folks are folks here in Vermont who are being charged with a federal criminal offense that are held.
Or potentially moved for not a federal, but they may be, for example, arrestees who are being sought in other states for state charges, and the marshals are the moving entity. So it's not only for federal charges, I don't believe. I think the issue is whether or not the marshals are the agency that's taking responsibility for these people.
So those folks would have precedence over available beds over the ICE folks.
Up to that number, the numbers.
80 males and 20 females. So, Jay, why don't you continue? I kind of jump-started and asked some specific questions, but if you could just talk briefly about the new contract with the federal marshals.
Sure. Again, I believe it's largely identical. It's my understanding the per diem rate increased, that the transport rate maybe is new. That had been a problem before. And I believe the bed allocation is new. I think it used to be 60 male. I can't speak to female, with what they used to refer to as a handshake agreement to take up to 80. So now it is 100 with 80 male, 20 female. I don't know if you have other specific questions as to how it operates to the extent it's largely identical. Again, it's the idea for healthcare. It's in facility, out of facility. And out of facility is the federal government's responsibility. Federal government, I think, needs to approve an out of facility transfer for healthcare. I'm not sure if you have other specific questions.
Well, I'm looking through, because I did read this, I did write in some questions that I have, and one question is on page 4. Where the local government, which I'm presuming is us, would maintain a review, classification, and housing process, and federal prisoners would be clearly identified as United States Marshal Service prisoners in the classification system. Do we also have a classification system for ICE folks? Are they identified as ICE folks as well within our system?
We do know which detainees are immigration detainees. That is tracked by the person who does tracking and classification.
So when you say immigration detainees, are you referring to folks who are held under ICE?
They're not, they're held under the Marshal's contract or CBP.
But I see what you're saying.
So they're not ICE, even though there is, part of this contract is to cover ICE folks? As the box was checked?
That's the entity that may have dropped them off. It's the entity that also generally picks up immigration detainees, but they're immigration detainees. That's the factor.
And is that how they're classified?
Yes,
As immigration detainees?
yes.
So to the question that was before, with respect to the numbers, we should be able to get you that breakdown. I think that was asked, and we should be able to get you that based on that question. To the extent that we're required to classify, we should have those numbers.
So if it's classified as an immigration detainee, would that encompass folks who are crossing the border who are undocumented?
Those would be immigration detainees as well, yes.
So ICE and those who are crossing the border, undocumented, that are crossing the border would be lumped together. So we wouldn't be able to see the difference.
I will have to determine whether or not because we do have a separate MOU with the Customs and Border Patrol, whether or not an immigration detainee brought in by Customs and Border Patrol would be classified differently. I'll have to clarify that for you.
So I think that's what we really want to get at, because we've always been taking undocumented folks crossing the border. We've always had a contract with the federal marshals for federal detainees, criminal crimes. And the ICE piece is a nuance that's been there over the years, but now it's getting a lot more focus than it ever has before, because there's such a national push. It hasn't occurred before.
Right. And I think to your point, there has been a lot of misunderstanding, and I know I can admit to it, is that because, say, the Border Patrol contract has generally been referred to over time as the ICE contract, and it really isn't an ICE contract, it's a question of if you are looking to understand who brings in whom and where do they end up and how long are they there and do they have access to the federal court system, that's a question we should be able to answer. And I can't answer that right now. And I just think that we should dig into that to the extent you want this more granular information.
I think members of the committee want it a little more granular. Yes. Questions? Questions?
I'm hesitant to kick this hornet's nest, but I think I should probably flag it because I'm afraid somebody might at some point. I believe that, and I may be wrong, but I believe that the term executive orders was added into the Vermont shall comply with, federal law, regulation, executive orders, and state law and regulations. So it is a very confusing, ambiguous term, given that. We were very careful in looking at this provision about the addition of executive orders. First of all, because it is being added to every single grant agreement that we're getting from funds to renovate the Bennington Battle Monument to, you know, a grant to DEVA recently for some genetic kind of counseling and testing. So we, as a matter of sort of operational reality, are faced with what do we do with these terms? Do we reject grants or do we continue with grant agreements, understanding what our risks are when they add that provision, right? So to the extent we are taking money subject to the executive orders to restore the Bennington Battle Monument, there are zero consequences there because it doesn't really affect anything that we could tell when we did the analysis. The other would be DEVA, pretty similar in terms of analysis. And there has been a case law, right, at the federal court level, typically some preliminary injunctive relief that's on appeal that hasn't gone to the emergency docket, which would prohibit the enforcement of, say, the gender identification issues, that some of the DEI issues, definitely the immigration issues. So we are looking at all of that carefully. There was a recent decision that kind of listed where you have these cases that haven't gone to the emergency docket, where you still have those, that injunctive relief is basically till the appeals courts weigh in and then the Supreme Court weighs in. But so for right now, I think that all we can do, if we want to keep operating as a government with federal money, is analyze the risks in taking it. The other thing about a term this broad, you shall comply with the terms of the executive orders and state law and policy, is there is so much ambiguity built into that contract provision that enforcement is going to be very difficult. So obviously in the DOC context, there's a gender issue that we are aware of and that we have thought about how to manage. So I just would say that it is a very complex issue that we know there is lots of, or should be, probably will be lots of concern about. But I just thought I should flag it because to the extent it wasn't in before, it is in now. And the thing is too, it swings both ways. Once this administration is gone in 4 years, whatever happens to those executive orders and whatever new executive orders are issued will also be applicable in these contracts. I don't think that anybody thinks that far ahead, but I do think that that is one of the consequences for the federal government in doing this.
Yes, you just opened up a big issue. What's up, Pandora's box? So how are you, who is doing this evaluation at this time? Because this is a concern that I would have, in particular with regard to federal executive orders. That's like.
So each time the councils for the agencies are doing the analysis. And when I get a grant agreement or any other agreement that requires the governor's approval, I vet that with the councils.
So. Yeah, so there are too many questions here to ask.
Yes.
I get it. And I'm looking at Ben, because he's going to answer them all and you're going to answer them all. So the issue, why have we included it at this time when it will be subject to litigation and questions both at the federal and the state level? Why are we including it? What is the justification and the intent for including the executive orders at this time?
Well, so are you talking about this specific agreement or across the board?
Yes.
Well, first of all, if we do not sign the grant agreements, we will not get the federal money for any range.
Signing a grant agreement is not assigning on to every executive order.
Well, that's what the agreement says, just like this one, subject to the executive orders,
So the
right?
executive order from where? From our?
Federal law.
Or federal.
Federal law,
So the
federal regulation.
The feds asking for that language to be put in.
Yes.
Or the feds are asking that, not
So
us.
even the Bennington, because I
Yes, we
just
signed
signed
up for it.
I just signed off on the Bennington Battleground Monument.
Well, I had flagged it.
Great green, super green.
Yeah.
But it does have in the federal executive order, would the federal executive order then be able to say something like that? No transgender individuals shall be allowed to
Go up
the monument after it's repaired. I mean, what are we
Here's the thing,
saying?
the federal executive order don't say that. So that's why it's a complicated question. First of all, for the most part, they apply to federal agencies. And the term itself shall be subject to the federal executive orders has very little or no meaning because it is so vague and so non-specific. We have no idea what the impacts would be, but because they are vague and non-specific, as a matter of general contract law, they are likely not enforceable. So it doesn't give the federal government the right to come in and say no transgender people can enter the Bennington Battle Monument. That is not what the executive order says. So it's a lot of rhetoric. It's a lot of information that's very specific to the federal government. And it has some very specific language that applies to certain things that in some cases has been stopped by the courts. And in some cases is not tested. So it's very, we're in a very, like you say, interesting time.
Yeah, I just want to make sure that we're not acquiescing to something that in the future will put us in significant jeopardy.
Well, we certainly are in the position where many would suggest we need to resist everything, right? But you can't run a government like that. To a certain extent, we have to trust our federal partners. And I don't think that those terms have much meaning. Ledge Counsel might want to dig in and advise their client. But like I said, each time, I didn't want to ignore it because I don't want it to be an aha, gotcha moment later. But I do want to say that it's a very complicated question, how we proceed to operate as a state without these federal agreements is a very difficult question. And it doesn't mean that we're conceding or capitulating or, it's just a matter of operating in a difficult environment with terms as a matter of contract that have very little or no meaning.
Can you just point out where that language is in the contract? I can't seem to
Page
find it.
2 or 3.
It is page 3, in section 3, and it states, and here's, I think, an important piece that the council's getting at. Northwest State Correctional Center shall comply with congressional mandates, federal laws, executive orders, and all existing Northwest State Correctional Center policies. There's going to be contradiction among
Right,
these.
there's
Right.
clear conflict there.
And there is ultimately I believe discretion, certainly I intend to execute that discretion when necessary, that our policies will trump anything other than federal law. That word was not a purposeful choice. It's just, they will override anything.
They might pull the money, 185 per day benefit.
Well, and then we would have no obligation to house the detainees.
And then what?
We would have no obligation to house the detainees if they're not paying for the beds. Part of the problem is we need each other in these contracts. So if they were to pull the money, we would not have an obligation. It's contract, right? So we would not have the obligation to house the detainees. We would not have the money, which would create a gap in our budget. But at the same time, we also have federal partners like the U.S. Attorney's Office and the marshals and the, ATF and the FBI and others who are working on federal criminal law issues and placing people in that facility. It's in our interest to have that facility there so that people can be heard in Vermont federal court. Otherwise, they're transported out of state and then back into Vermont for proceedings.
Questions of the member? Commissioner, do you want to weigh in before we transition to other items on our agenda?
No, I'm.
So you weren't personally the person that negotiated the new contract as well as the new MOU. It was the deputy commissioner
I signed both.
who signed them.
Yes.
But in order to do the actual negotiations, it was the deputy commissioner of corrections, correct?
Deputy Commissioner Calver had the point in liaising with the person on either side, both the marshal and the person at CBP, who were the point on their ends for the contract. But in both cases, I'm certain that it was being reviewed by counsel on both ends. And the negotiation really was emails back and forth of, have you sent it to us yet? We were reading it, and yes, we're okay with it, or no, we're not okay with it, or we're giving it to, this group to look at. Where are you with it? Why, we sent it to you on the 26th of August. Why have you not sent it back yet? That kind of thing. When I don't want it to be misconstrued that negotiation was some sort of point by point review of the document whereby Deputy Commissioner Calver was saying, this is what we will do and this is what we won't do. That is something that we really leave to counsel. But insofar as saying we've gotten approvals, our various parties have looked at it and we are okay with signing this, it was Deputy Commissioner Calver who had the sort of email back and forth, but I am the person who signed it and chose to execute it.
And when did you come on board?
August 15th.
August 15th. Yeah. Just trying to get the dates in there. Any other questions before we move on? Okay, I think the next item on our agenda is the Chittenden Accountability Court. This new agreement that was made between the governor and the mayor of Burlington. I think, Commissioner, you can get off the hot seat for the time being.
Sure. DOC is happily playing a role in it as well, and very happy to do it. But
That's with the pretrial supervision.
and with additional kinds of treatment that we are putting into place in the facilities. If we're going to hold people more accountable and bring them into facilities when necessary, we need to be able to treat them as well and not merely warehouse.
Okay, so you'll be coming in, we'll be dealing with that. So let's transition. If you, Jay, could give us an overview of the new agreements that the governor and the fifth floor have made with the city of Burlington, because there was also last, I believe it was Friday, a list of other items that would now in. So if you could give us an overview, and then we do have some of the respective parties here, at least for the court piece. And we will get into the DOC part as well.
I do have a copy here of the 14 points. I know that there's a link in the governor's press release. I don't know if you want that in front of you or if you wanted me to just go through. I have one copy.
Copies,
Yeah.
yeah.
And the link is on Justice
Oh,
Oversight
okay,
page.
that's fine then.
Yeah, and in the press release
Okay.
itself is the 14
I would
points.
like a copy if we have.
Same here.
Thank you. Yeah, never have too much paper. That's all, probably opens a whole other can of worms. Yes.
So can we refer to it as like the expedited arraignment docket or?
We can refer to it as the blueberry if you would like. I mean, so as we conceived of it, as the court has been conceived of, and again, I would just like to sort of start where we started. The governor convened a meeting with the Chief Justice Reiber, Judge Zone, Terry Personnes, State's Attorney Sarah George, Executive Director Tim Lueders-Dumont, State's Attorneys and Sheriffs, Matt Valerio, Defender General, and the AG's office was present. Todd Delos, Attorney General Clark, and Domenica Padula, who's the chief of the criminal division. And we basically, the governor's office presented the idea of a new docket, which we were referring to as the accountability court, community accountability court, but really for the purpose of making the point that this is a court for moving the cases of individuals with 5 or more cases in Chittenden County. This is a list, so the judiciary has actually already been working on some of this. They have been producing a list of the 5 or more cases or individuals with cases in each of the counties and producing those for the state's attorneys. So it is, I'm pretty sure Judge Zone can speak a little bit more to the kind of work that the judiciary has been already doing in this regard. But of course, in the context of the backlog, how do you start to clear misdemeanor cases when you have a lot of felony cases that are taking up the time of the courts? And what we realized, and I think what most people realized, sort of coming to a head earlier this year in the fall, is that things were not going well in Burlington, and that while the mayor hadn't specifically asked for a response plan from the governor, she would like to hear if the governor had any ideas. So we came up with a near-term response plan, understanding that there are some things that, there are policy changes maybe that may or may not happen in the legislative session, but that maybe there were certain things we could do short-term as, together as the judiciary and the executive branch. So in that meeting, it was identified that there is a fourth courthouse or a fourth courtroom available in Chittenden County. And that's used sometimes, but hadn't been used for trial in several years. We identified sort of the idea that the governor would appoint a special prosecutor to prosecute these cases. The judiciary, if they were interested, would think through since it's a judicial courtroom and court, how would they do it if they were to choose to participate? And the Defender General was thinking through, how would you designate lead counsels? Is that possible? Is that something we could do in terms of just designating a team to move through these cases? But it's not just about, and then there's the state's attorneys and sheriffs have been instrumental in helping to think through the kinds of staffing that's needed to support a special prosecutor in this kind of an environment. You need victims advocates and you need court administrators. The state's attorney, Sarah George, has been incredibly helpful in actually stepping up to provide the resources for this short-term period. And again, the thought is it's probably a 3 to 4 month project, pilot, so to speak. And so the way that had evolved actually successfully as of last week is the court was able to say, yes, and Judge Zone can speak to this more fully, but there is a judge assigned, retired Judge Maley. The courtroom doors opened Monday morning, the lights went on, and the process is going forward. We appointed as our special prosecutor a deputy state's attorney from Washington County named Zachary Waite, who is the special prosecutor. He has, in a week's time, done an extraordinary job reaching out to service providers, trying to get to the chief of police. Obviously, that will be a key connection, working actually already with Burlington, what Burlington has set up as a situation table, and working with Judge Maley and the defenders, I think fairly productively to sort of talk about how this court. And so at the end of last week, I think we had a fairly, for a process that has 75,000 moving parts, it's moving forward. It will help when we have, I know that the special prosecutor was identifying sort of a winnowed down list of cases where we really are just talking about the 5 or more misdemeanor, high impact, low crime type, but multiple crime type offenders in Chittenden County. And but again, this is a court process. The judge will, in the end, determine who is in and who is out for purposes of being scheduled in the court. And then the idea, which I think Judge Maley apparently has really been instrumental in is the idea that you have to be present. You have to have the prosecutor present. You have to have the judge present. Thank you. The defenders are there in the courtroom and people are coming to court. And the idea is bring them in, not in 30 or 40 days, but in a week and moving, connect. But key then to all of this is not just moving cases, right? We're not just clearing the backlog. We are, and this we will see how we can do, but how do we connect people in an appropriate way to the appropriate level of services in the appropriate setting, right? So sometimes that's going to be incarceration. Sometimes that's going to be placement with a service provider. And last week, I believe they had already made some successful placements with service providers. All of this is going to test the system. You know, we'll see where the stress fractures are. We'll see what works and what doesn't. But I think everybody who's involved has been thinking about this a little bit creatively, in a way that you can't do when your caseload is jammed with serious felonies and you can't really move the misdemeanor cases. And again, we're talking about high impact individuals here. So that's the goal. And like the commissioner suggested, there has to be AHS backup here, right? There has to be AHS support, because what we're seeing is this kind of crime, lots of retail thefts, disorderly conduct, vandalism, drug use, drug possession, drug sales. A lot of this is obviously driven by drug use and addiction issues, and it's driven by mental illness in many cases. And worst case for Vermont, since we don't really have a way to manage this, is co-occurring disorders, drug use and mental illness. We tend to separate everything into a silo. And if you are mentally ill and taking drugs, but you're mentally ill, you're over here and we don't treat you for your drug use. I think we're working on that. And Commissioner Hawes is very involved in this process, discussing how to improve systems, but it's difficult the way that our systems have evolved. Anyway, but that's key to this, right? The way to stop this kind of crime in our communities and address some of the drug supply that's coming into the state is to reduce demand, not just harm reduction, but reducing the number of drug users in the state by people sort of be free of their addiction. So as opposed to having the choice of dying from an overdose or taking drugs, you now maybe can get into a justice system that applies a little bit of pressure, which people don't like to think about, but helps people, incentivizes people to make those choices. And in some cases, places them in a facility where they have access to long-term treatment. It's true right now, the only drug treatment on demand in the state is in DOC. And that's not treatment. It's not long-term treatment and recovery, but it's maintenance medications. That is great because they are there. They can get sober. They can get through the worst of a withdrawal in a supervised setting, but then they're released into the community and we start the cycle all over again. So anyway, the other points that are key to this idea of a pilot criminal docket to handle misdemeanors is immediate implementation by the Department of Corrections of pretrial supervision in Chittenden County, which had only been rolled out as a pilot in one other county, and it wasn't really there was not a lot of uptake. And I know that DOC's probation and parole has already been meeting with the special counsel. Then expanded substance use treatment in the DOC facilities. So actually providing not just the maintenance medications, but therapies, the recovery coaches, the things that are necessary. That's obviously a little bit longer of a time frame, and maybe the commissioner can speak to that at some point. But they have been working with a consultant because the last session, the legislature did appropriate money for a study. And that study has been ongoing, and there are some really exciting results coming from that company. So we've basically said to them, we got to move this up quickly. We need to be able to do this sooner rather than later. And they said, great, it's an opportunity that they see several states trying. And Vermont will be definitely a national test case in this regard, from what they were telling us. Then we will build and staff a multidisciplinary team, including AHS, Public Safety, Burlington Police Department, and Burlington service providers, sort of like the situation table concept that they have now, meets once a week. We would have, though, that group ideally advisory to the special prosecutor and the judge and the defense bar in order to help settle these cases and move them. Again, connecting people with the right services in the right setting. To me, it sounds easy. I probably make it sound a little bit, but it is, and I get that it's going to be full of bumpy roads, and relapse is of course part of this process. But I think that to the extent you are not showing up for court, you're getting called in the following week or the next day. And if you need bail imposed in order to help you get to court, you are gonna, maybe have bail imposed, right? We have an engaged prosecutor with an engaged judge and an engaged defense bar who are there working to, I think, get people, again, the appropriate level of treatment in the appropriate facility. So that's the goal, from my perspective. And I think it gives us an opportunity to see all this in a microcosm and see if there is a way of moving forward eventually with some or all of this. Because we do have the same problem in every other county, and we realize that. We have the Washington County State's Attorney, Michelle Donnelly, lent us Zach so that she could, because she's particularly interested in the success of this. So anyway, it's got potentially statewide implications, and we think it's a great opportunity to start to. And then there's the other 14 points, which really are designed to sort of shore up some of the work, and open Burlington for business at Christmas time.
So we have some questions.
Yeah.
Sure. And then Jim.
Yeah. First of all, thank you. I think, for the most part, I agree with this plan, and it's, certainly very consistent with what we've been looking at the last 2-3 years as far as what needs to be done to address the public safety issues. And what this really seems to focus on as far as one of the prime levers that we've been trying to pull is the resources for the criminal justice system. And this is providing it in a really directed way. And I guess the question I have is why the 3 to 4 months? Is that somewhat resource related? Because it's
I think to the extent it's a pilot that was intended to operate it really is a pilot intended to operate in a short term to see what sort of happens and how well we do, where things are working, where they're not. And then we're into the legislative session and we have the opportunity to discuss this with the legislature.
right. So I guess, is there going to be a request for money from what's that called?
It kind of depends.
Budget adjustment.
Yeah.
Oh, yeah, we would expect that there would be an ask and budget adjustment.
So how are we going to track how well this is working? I mean, what are the data points that we're going to be trying to make sure that we are, this is, again, I think this, I really agree with, this is the way we should, be approaching this issue. But want to make sure that it's a successful pilot in that we understand what is and isn't.
Well, so I actually asked the special prosecutor that question on Friday because I think we do need to start to think about what success looks like. It is more than clearing cases, right? So we can count the number of cases, the dockets and the backlog that gets cleared as a result. I think that what we really need to do is work on identifying, and I know we're working with the prosecutor on this, and I think we will be relying on the courts and DOC and others for metrics that I guess we need to sort of think about how to articulate. But it's not just money in, money out, people in, people out. It's going to be how well are we doing connecting individuals with the resources that they need. 3 to 4 months is probably too short a time to know if a person is going to reoffend, go through some kind of a treatment process and then back into the community and reoffend. But but that's the idea, is it's more qualitative than quantitative. And I just also would like to point out, I'm sorry to interrupt, is very often the response is restorative justice rather than incarceration. I think we need to start to think a little bit about incarceration as a place where people have the opportunity to heal. We are often returning people into the community, which is the right thing for many people. But to the extent we are dedicating a lot of resources to restorative justice with some very, very nebulous outcomes, this is not a population that we have seen responsive to restorative justice, right? I mean, these are people with more than 5 dockets, more than 5 cases in our court system. Over, I think statewide, something like 1/3 of all cases in a very small handful of individuals. So I think that while we tend to say, great, restorative justice is the answer, it's not always the answer. And I think we need to maybe think a little more seriously about that to the extent we're dedicating resources to, across the board. We asked for in the last session a continuum of care plan so that we would be expanding drug treatment services across the board from inpatient beds, crisis response beds in the community, all the way to long-term treatment beds in a facility. And $1 million went to pre-charge diversion, and nothing went to our proposal. So I guess I would just like to highlight that this will be an opportunity again for the administration to come back with our proposal from last session, because this is part of that. Something I've experienced is I only ever testify in the judiciary committees on criminal justice issues. And last year, and I'm pretty sure the last year or 2 before, have flagged this intersection between criminal justice and human services. And I have never appeared in a human services committee. So I don't know if that's interesting or necessary, but I do believe that the two have to be thought of together with respect to this forensic population. And I know that that's difficult in many contexts.
So I just need really quickly that the restorative justice component is an important component, and I agree that it's not the right for certain populations, probably this population, it's not. But the pre-charge conversion is pretty critical as far as taking pressure off the courts of a different population where it is appropriate. And so I'm just pushing back that I think that both of those are critical.
Sure. Yeah, and I anticipate
housing is both.
Yeah. And those outcomes I'm anxious to see.
Yes. Yeah, and we're going to be starting to see better data given the pre-charge program that's being put in place.
That would be great.
Any more questions?
So, yeah, thank you for this. I think Burlington has been under significant stress. We all know that, and that responding to Burlington's need is important. And, in spite of the fact that the governor and others in the governor's office have said they've made their bed and let them stay there, I think I disagree with that. And the reason I disagree with it is there are people who come from outside of Burlington and outside of Chittenden County to seek relief and support because we have significant services available in our county. So I will leave it at that, but just to say that there are folks from our rural towns, our rural counties who have sought solace really in Burlington and in Chittenden County. So, boom. And I will then also respond to your question about coming into a committee. I will invite you in.
I wrote it down.
And I have had.
You'll say no now.
I never say no.
I have had Monica Hutt in, who is the chief prevention officer and sits in the governor's on the 5th floor. So she's been in, so representing the executive branch exceptionally well. I want to make sure that the work that we're doing here, because you've expanded from Burlington and judiciary in Burlington to the broader state problems that we have, and to the report that's coming in December, that I asked for in S-186 last session, which will look at the gaps and the needs across the state for recovery for residences and so on. I look forward to that because I will base much of our discussion and our legislation and policy on that report. And I know that the Department of Health, substance use disorder folks, Department of Mental Health, and others are working hard on that. And I'm glad to see the governor's office paying attention to Burlington in this area. Just to reiterate that, it's a great thing. The courts are working, the judiciary's been working very hard on a sequential intercept model, which very much reflects the work that you're talking about. So this is another step in the direction of bringing the courts into solving our substance use disorder and combined problems with mental health to resolution. I just want to, and I'm going to make another statement. I'm going to make a couple statements because this resonates with me greatly. I've worked professionally in this area for too many years. I won't say how many because then I'll look older than my white hair. The point is, you mentioned how important prevention is. So I am hoping that within the budget that we see and approved by the executive branch, that there are funds available for prevention and included within that, preventing kids from access to nicotine and vapes. Huge gateway, big gateway. So all of the good things that we're doing at the tail end to bring people into restoration, recovery, treatment, all of those good things that are here within the court system, that's critically important. But you also brought up the critical part of prevention. I know others around this table have worked for a long time on prevention. So we need to see that reflected equal parts. I shouldn't say we don't. We do want the work that you're doing to identify gaps and identify needs. That's part of the report that's coming out in December. My question for you is, how are you with this proposal integrating with the report that's coming to us related to substance use disorders, mental health, co-occurring disorders, community-based services that are needed, the healthcare transformation work that's going on? And I include that because Burlington is the hotspot for that work. If we can integrate as the UVM Medical Center has with its emergency mental health clinic, that's outstanding, right? So that's part of Burlington. So my question is, how are you, as you're doing this work, how are you identifying proposals, gaps, issues that we need to see legislatively to build a stronger system? Because you also talked about a systemic approach. That's what we do in the legislature. I try to work very closely with the Judiciary Committee. We all work together across the House aisle and elsewhere. So we haven't heard this proposal before, but it certainly resonates with the work that we are doing. And my question of you is, how are we going to continue that systematic and systemic approach across all the aisles that exist, all the little complexities that exist?
Well, I guess first, the good news is Monica Hutt and I work very closely together in the governor's office. So there's that. I have to honestly say that I have not integrated this work with AHS into the report. I think this was much more short-term operationally focused. So we certainly can and should be, to the extent we are working closely with AHS on this project, talking to them about how they see, if they see this integrating into that report. We have some very specific questions for AHS in terms of operations, things like working with the Department of Mental Health to walk through the orders of non-hospitalization process. What does that look like? Why does it seem to peter off and fail? And so that is a process that we're undergoing right now. We're going to be meeting on sort of mapping that out. Where do things fall apart? How do we, I mean, it's a court ordered, it's a court order.
Got it.
People don't ever go back to court. So how do we walk through that process and figure out where it breaks down, how it can work better, how people can actually stay with and receive the treatment that they need? So to your larger question of how are we going to come to you make proposals, that is yet to be seen. We are going to see, we're going to get very specific feedback from the prosecutor on what is needed. I know part of that already is having a warm body from the social services network in the courtroom at the time that the judge and the prosecutor and the defense bar are working on a resolution. So that should, in the first week, was very difficult because it was, they were really just working out order of operations. In the coming months, November, December, as they work on scheduling, that should be more, I guess, predictable and potentially doable, but we will know if that's possible. Obviously, a lot of this relates to our declining demographic and our manpower shortages that we have in Vermont. Just having social service workers available to do this work is difficult. So there are lots of those kinds of issues that I know the governor is working on housing. The governor is working on making Vermont more affordable. The governor does recognize that this needs to be done for Burlington because, the first thing that happened was the statewide response of what about me? This isn't fair. Why does Burlington get everything? They already have all the resources.
So can I stop you right there? Because that is an inappropriate way for folks outside to look at Burlington. And there's two reasons why that's the case. One is what I said earlier, that people are coming from all over the state to seek support. The second is that Chittenden County is the economic engine for the state. And we do provide support for the rest of the state. I very much love my rural parts of my county and of the state of Vermont. But to bring that up every time as a complaint, it's time for us to say why it should not be the complaint that it continues to be. We need to continue to work to expand this service to the rural parts of the state, but you can't expand something until you've tried it. So that end of my litany.
Right.
That comes from the southern part of the state.
Well, and that's the thing. We do, as it's just a difference of view when you're the governor and you represent the entire state. So I think there is that. There are county economic centers in every other county, and the governor can't ignore that, right? That is just so that is maybe a lack of opportunity in many of those counties, but we don't need to debate that right now. I just would say, though, that Burlington is more well-resourced, but the fact is you're correct, right? People come in, we had somebody who came in for a conference and was mugged. We saw Burlington on the national news. So this is, how much of this was Burlington's own making is a little bit irrelevant when you're trying to move forward. Whether a 3-month project, like I said, the governor's proposal is short-term. The court is 3 to 4 months, and that was the specific question. But generally, as a proposal, it's because we can step in, we can do what we can do, and then we are not there as Burlington's special resource and pocketbook. Burlington is going to have to step up and use its considerable resources to help itself, I think, is going to be part of the answer. Anyway, I would just say that moving forward, we will have a statewide view. We have to have a statewide view. And so, that's just, I understand your very specific concerns and your constituency, but we do need to move forward on a statewide basis.
My constituency is the state, as I sit on my committee as Chair of Health and Welfare, it's for a systematic approach to state problems associated with both healthcare and with substance use disorder, mental health, and others. My constituents live, some of them, in a little tiny bit of Burlington, but that makes all of Burlington a concern. But it should be a concern for all of us. As it is, you've done a great job here. Thank you.
Teresa.
Okay, thank you. I have I guess a couple of questions. First off, we did review the governor's proposal last year. And, you know, frankly, at the time we were making our decisions, there was a lack of consensus in the broader substance use disorder community about even really what the proposal was, because they hadn't heard about it prior to, you know, the Commissioner of Health presenting it, you know, in a little bit more detail, although really, frankly, not a lot of detail to my committee. So I think, you know, as the session wore on, more information became available, but, you know, insufficient, frankly, for us to make a decision. So, you know, that's going to be important if that's something that you're going to, that plans to reappear. I guess I'm a little concerned when I look at the you know, program as it's laid out, that when, you know, we're talking about the Agency of Human Services working with local service providers, it concentrates on law enforcement and calling law enforcement when there's disruptive behaviors. And it doesn't recognize places like the Howard Center, who's had to actually condense their programming for substance use disorders. And they no longer provide public inebriate services, and those folks are being transported on an ongoing basis up to St. Albans. And so I really don't see that addressed at all in the governor's proposal. So, and to me, while I recognize there needs to be a balance between restorative justice and incarceration, and I would agree with you that I think, you know, perhaps some of these people are not as receptive to restorative justice. It feels like that, again, is going to exacerbate the issues that we're having in our correctional facilities, you know, with staffing and, you know, ongoing support. And I guess the one thing that I do know is that, you know, for whatever period of time, substance use treatment and mental health treatment is not generally successful unless it is voluntary in nature. And it requires, you know, ongoing support. And I just don't see that in the governor's plan here in terms of how will people be supported, you know, once they're discharged from corrections, if they end up being incarcerated, how they're going to be supported in the community with the appropriate, you know, substance use and mental health treatment. And it's not all going to be by O&H. So it doesn't seem to be present to me. And if it is, then that would be great.
So I would say that's part of the point of the interdisciplinary team, is that you will have a team that is thinking through the longer term needs and the appropriate placements of the individual. To step back just to this point on voluntary treatment, I certainly don't have the data at my fingertips, but if you listen to Professor Keith Humphreys, who recently did a Times editorial, or not editorial, opinion piece. He has been on the Ezra Klein show in May of 2024. He is a professor from Stanford University who actually would dispute, I think, the point that you just made about voluntary treatment being discernibly more successful. So you're talking, and what the point he makes is you're often talking about mandatory treatment versus voluntary treatment, where what we're talking about really is mandatory treatment versus no treatment. And what does the success rate look like there? The other thing I think Professor Humphreys would dispute is that voluntary treatment is noticeably more successful than mandatory treatment. I would have to have somebody dig into what that data is, but maybe that's something that we need to ask ourselves, if that's true. Necessarily.
And I would probably wouldn't dispute the fact that mandatory treatment versus no treatment.
Yes. And that's what we're talking about, is a very service resistant repeat offender population.
I do understand that.
And
I feel like I still feel like, that there's I guess an insufficient, I won't say lack of then, insufficient focus on the community-based services that will need to follow these folks if they're going to, make changes in their life that are, that society accepts more than what they have been doing. And as you pointed out, the folks have recurring issues with law enforcement and their behavior in the community. And so that will take some period of time to break those cycles. And I just, we see continued issues with our community-based service providers receiving insufficient funds in order to be able to continue to step up for the things that we're asking them to do. So,
yeah. And I can't speak to that specifically because I'm not, an expert in the budget, but I do believe that the designated agencies have gotten significant increases over the last 5 years. That aside, I think that one of the concepts that maybe folks could think about, if not get comfortable with, is the idea that I agree that you do need significant time to rewire your brain when you've been addicted to fentanyl and living on the street. But if for your own dignity and your own well-being, you're in a DOC facility for, say, a term that is appropriate to your crimes, you say are there for 6 months or 12 months or 18 months in a substance use treatment, basically inpatient treatment facility, that you have greater success at succeed. I mean, you have greater chance of success when you're just released and put into the street with a connection to a service provider, right? I would agree. We need a plan for placing people in long-term care facilities. So that was part of the continuum of care. And I will be sure to talk to the secretary about providing sufficient information. But the idea was you beef up the resources for the Valley Vistas and you open a long-term treatment center in the Northeast Kingdom. And I mean, those are the kinds of things. But again, to the point that DOC is the only place where you can get treatment on demand, you can actually, if we can pull it off, be provided a long-term treatment plan in a facility where then you do get connected with recovery housing, you get connected with, vocational services, you do get the supports that you need. I mean, DOC is unique in being in our Agency of Human Services for a reason, right? It's rehabilitative. So let's use it for rehabilitation.
And Jenny?
Yeah, just a couple comments here. It's all really, everything that you're saying is important. And I'll go back to the workforce issue that you mentioned earlier. That's really critical. We know that our DAs and our SSAs are feeling the stress very much. But one of the problems that we see, I know you said, I know we've given increases in reimbursement through their contracts. But they don't even rise to the level of private practice. And that's true for many publicly funded professions. The other thing that you've raised is having long-term residential care facilities. Putting those in place without having them in context with the short-term residential facilities and with diversion programs, with other things, doesn't make sense. Jenna's Promise is unique. We know that. And I think we all think it's good, but it is costly, and it's costly for the people who stay there. And those folks are there long-term because they have a long-term illness. Their addiction is lifelong. And we know that people coming out and going into the same culture are not going to do as well. You alluded to that. We know that we need to do something culturally to help them find a job. And Turning Points of the world are terrific. Finding the job in Burlington, a very good turning point program that I think would be part of this court process that we're talking about. But the recovery initial recovery can take a long time, 5 to 7 years. And there's not a way for us as a state to put long-term recovery programs in place. I don't think, correct me if I'm wrong, maybe the governor will put in his budget some long-term funds for 5 to 7 years for every individual who needs it. But I'm not seeing that. So everything that you're talking about is right on target, but it belongs in a system. And all the other things that we're concerned about, including housing and workforce. I don't want to leave us with the notion that this short-term judicial fix is going to be the fix. No, it's a start. It's a beginning to the sequential intercept model that I know that Judge Zone is very familiar with, and more than I am. But there's a lot to be done here. So I don't want us to go away thinking that this is going to fix everything. It is going to help Burlington cope with the problems that it has. It is going to help with our state's attorneys and our defender general very much, I would hope. That's all I wanted to say. I didn't want to leave us with a notion that building more long-term residential care facilities is going to end the problem. Because I don't think we have the resources to do that. I really don't, unless we have some gift coming to us.
So yeah, and I have no illusions that this court will resolve all of the problems, but it may resolve some of the problems in a way that we are not able to do now.
So we kind of blew the schedule. So we anticipated when we put together the schedule that Jay would be here for maybe 5 or 10 minutes to give a broad overview. And then we could go in and discuss with the judge, defense, state's attorney, and the city of Burlington this issue. So I'm a little trying to, and we also scheduled VSCA to come in on Thursday. So I'm trying to figure out how to work through this. So any suggestions?
I think we will know, or they will know a lot more by the 20th when we meet again and have them come in and talk to us about it then. Because it just got off the ground last week.
Right.
Yeah, so that's.
And we have Burlington folks here.
Yes.
At least I would like to hear if they traveled.
Yeah.
I know you've traveled too. But I would like to at least give a few minutes to Burlington. And would people be willing after that to listen to VSCA? And then take a late lunch? You have a meeting at unless we listen to Burlington and come back at 1:45, would VSCA be available then?
Yes.
So let's hear from Burlington real quick. We really need to hear from you folks, the judge and defense and states. Feel really that, Judge, you're back this afternoon.
Yeah.
DOC, I've got a lot of questions with DOC. You're in this afternoon. And Matt and Tim, I don't know what to do with you two.
Or do you want me to come back in a month? I'm fine with that.
You're fine with that? And you, Tim?
If I could just state for the record very briefly, and then I'll come back in a month, that the collaboration between the state's attorney, George, and the governor's office and the special prosecutor is incredibly unique. And the direct quote from state's attorney, George, is it's going great. But we also need to ensure that if it's going to continue to go great, that there are resources at the table. So that's just the direct quote, and that's something I think is very unique and even historic in the last 10 years.
Yeah.
I've never given Karen an opportunity to testify.
We'll tell your mother that.
Thank you.
She probably already knows it.
Thank you.
And I know, Matt, you were here at our last meeting talking about how your staff is really stretched. This will have implications, I'm sure. Your staff, because you're pulling, same with the state's attorney, you're pulling for that, so. Anything, I want to say real short?
No.
So we'll schedule
I
you.
think it's a lot more complex and, I have my ideas, but I'll have better ideas.
Great, we'll schedule more time for you folks. And this afternoon, the judge and the commissioner can weigh in a little bit, because I do have questions about DOC. So Burlington, why don't you come on up real quick? Jay, you can get out of the hot seat.
Thank you so much.
Really well.
Thank you. Thank you.
Welcome.
Thank you. Good morning.
If you could just identify yourself for the record and.
Absolutely. For the record, my name is Erin Jacobson and I am Mayor Mulvaney Stanek's Chief of Staff. So, I will try to be mindful of time here. From Burlington's perspective, first of all, the process that led to the community accountability docket and the other pieces of the governor's response plan was a very constructive process with the governor's office and our office, and was also informed by a lot of feedback that both the governor and his team and our office heard and collected feedback from a number of stakeholders, including community service providers, local business owners, other community members, and of course, the folks who have a direct stake in what is happening in our in the criminal legal system, like our Burlington Police Department, our Burlington Community Justice Center, even our fire department has a direct link to our health and safety response as it relates to mental health and substance use issues. So we, of course, talk to them as well. But it was a very collaborative process. And though this response plan that of which the community accountability docket is a part is intended to be very much a short-term 3 to 4 month response plan. The governor's office also heard loud and clear from us that we know, and as we've been saying for a very long time, that what we need if we're going to be able to turn our health and safety issues around is longer term resources. I don't want to diminish the appreciation I have for this immediate response, because one thing that Burlington has been struggling with for a long time is our ability to have immediate interventions in a meaningful way. We have a police department that is understaffed and that we are rebuilding, and they're doing what they can. As I've mentioned, we've also resource our fire department in different ways because the Howard Center did receive fewer resources this year than is needed in Burlington. The city of Burlington has stepped up and provided significant financial resources to Howard Center in particular, so that their Howard Center Street Outreach Program can continue, which we feel is a critical response resource for Burlington. We also, on the response side, for what we've been trying to do in Burlington, we have, with the state's help, established the situation tables, which is all the community service providers and the safety response folks getting together weekly to talk about making sure that high-risk folks are getting what they need. And we are also about to roll out what we're calling community circles or city court, which is utilizing the city attorney's office and their ability to prosecute low-level ordinance violations. Many of our ordinance violations can carry criminal fines, so we are able to use the pre-charge diversion program to help resource that effort. So all to say, we've been doing everything we possibly can to increase what we know we need, which is this immediate, swift, consistent intervention for folks in order for them to be able to turn things around, in order for victims to get what they need, which is something that we haven't had in Burlington for some time, since COVID. Certainly the court backlog has contributed to this. The lack of available resources that people would be provided should they go through the criminal legal system is lacking. So this immediate response system is hopeful. as Jay Johnson mentioned, we know what will happen in this community accountability docket is gaps will be identified. And so that is where the city has a lot of curiosity, is what happens when folks who have not been responsive in the past, who have multiple charges against them, who are not engaging with restorative approaches. What happens when what they need is long-term treatment or maybe some incarceration and then treatment in the community? What if those resources are not available right now? This is an open question, I think, that a lot of communities have, not just Burlington, but how do we get those additional resources we know we all need to really be able to increase accountability and behavior change? I did have the opportunity to observe the accountability docket on Friday. I highly recommend everybody to go observe. It is an amazing case study in what is happening in our communities, and not just Burlington, because Burlington is not alone. But what I saw was an amazing effort by Judge Maley, by the special prosecutor, by the defense attorney, by the court staff, to really address folks who've fallen through the cracks. And the case that I saw was a young man with multiple charges against him who actually did not show up on time. And then what happened from there was the judge ordered the defense attorney, and with the help from court staff, to call the defendant. There was a recess, which gave me an opportunity to talk with special prosecutor Zach Waite. He's fantastic. We called in the Burlington Community Justice Center folks. Everyone tried to figure out how we could get the individual into the courtroom, and that was successful. He was late, but he came into the court. And then the judge spoke from the bench. He directed his comments to the defendant, and he delivered what he described as his accountability speech. And it was about expectations that people will show up in person, that they will show up on time, that if they can't for some reason, it has to be only because of an emergency, and then they need to let people know. He talked about the accountability of the people in the room as well, the people who are there to help connect people to services. And he talked about how he is even willing to make sure that if what seems to be needed is weekly status conferences, then that's what will happen. Towards the end of the hearing, which was just a status conference, when the judge and the defense attorney and the prosecutor were deliberating what should happen next for this individual, it was clear that he wasn't going to be held, he wasn't going to be detained during proceedings. But what was needed was some pretrial services and pretrial monitoring. As I understand it, the pretrial monitoring program from DOC will be starting up this week. So that wasn't established as of Friday. However, the pretrial services folks who work for the diversion program were there, and they were able to ensure that their role, which is to connect people to services, but they don't have any enforcement powers, they could work with the defendant to identify what the needs are, to begin to help connect this individual to services, even though he's been service resistant in the past. And then when the pretrial monitoring program is up and running, connect to that probation officer who does have enforcement authority. So there's the pretrial monitoring program run by DOC and the pretrial services offered by the diversion program, working in concert to help make sure that the individual is showing up for court and is meeting with service providers, and is able to take advantage of the services that have been identified as what he needs. And then if that doesn't work, then I imagine then, as Judge Maley indicated in his accountability speech, he is willing to impose something else like cash bail. That was just for this one individual. So it gives me a lot of hope. And it will be interesting to see what is identified as needs and if those resources are available in our community. And if they are they long-term resources that he can continue to access should he need long-term access? I would also say that I think the partnership between pretrial services and pretrial monitoring, I'm anticipating that will be a critically beneficial partnership. That because there's the both and there's the services, and then also there's the enforcement authority. The enforcement authority helping make sure that someone continues to engage in the court process throughout the pretrial. That is something that I'm hoping works as it's intended to, and I'm hoping we will be able to maintain as a program in Chittenden County Court beyond the 3 to 4 months that the governor's response plan is designed to be implemented in. I think those are all my comments for now, and I'm happy to take questions at this time.
The example that you just gave is very hopeful, but it is so labor intensive that I just wonder how it can be sustained on a daily basis in all of our court systems eventually. I mean, I agree with what you just laid out and the outcome of that, and that's what we should be doing. In fact, we tried doing that way back in 2008, 2009, 2010 with Justice Reinvestment One. We put in actual folks in the courtroom to help, and then the funding went away and out the window with folks. But it is so labor intensive, and then when you start getting in a lot of numbers of folks needing this, it just doesn't fall under its own weight.
I hear that. I agree. It is labor intensive. And I think some of this is when you're looking at the system as a whole, sometimes the question is, where are we putting resources? I mean, right now in the city of Burlington, some recent data from our Burlington Police Department indicated that the top 20 people just in downtown incidents, the top 20 people have been tied to 842 incidents this year to date. And actually not even to date, that was just the end of September. So there's a lot of impact on that front end that is just people cycling through, leading to a sense of, lack of safety in our community, huge economic impacts that we are not going to be able to turn around unless we have some additional resources towards the end of that sequential intercept model. And we see this all day, every day in Burlington. I know we are not the only community seeing it. And unfortunately, I think until we have those additional needed resources around treatment and health, we're just going to continue to see 20 to 30 to 40 people causing a significant amount of community harm and economic costs.
We have a question here, Wendy.
Thank you. At our last meeting, we heard a lot about transportation challenges of all sorts in this system. Can you speak to transportation in the pilot program?
If you can, I think Jay Johnson can. Not sure.
So thank you for that question. So we understand transport is a problem. We didn't want this all to fall apart on transport.
Let's be clear. What type of transportation are you referring to, Wendy?
We're really both. I mean, transportation for folks to get to court, and then transportation within the system. Because what we heard at our last meeting, and I'm aware of it in many situations, that is a barrier in many cases.
Well, when you're talking transports, it's from a correctional facility to the court. When you're talking, if a person's not in a correctional facility, it's their access to transportation. So you're talking for both, right?
Yes, both. And if we want to get more expansive, there are challenges for folks who are sent by the state to particular places, and the state pays for that transportation, but the state does not pay for them to get back to their home if they want to go to their home. which isn't, I just think that should be mentioned here. But transportation is an issue. So I don't see, it seems necessary to me that you include transportation in your plan.
So I should not have raised my hand. No, because I didn't know it turned into a three-part question, but I do think I can respond to two of the parts. With respect to what you're saying, Madam Chair, is transportation from the facility to the court. We know, and the executive director for state's attorneys, sheriffs can speak to this, that the sheriff's deputies who work for the state are the transport officers. They, like everyone, are stretched. They are scheduled out, from what I understand, 2 weeks in advance now. We spoke with the sheriff in Chittenden County. He started to go through a weekly schedule of transports, and that is a factor, and some are located in Springfield and some are located in Newport, and bringing them into court in Chittenden County, that's logistically difficult. And so anyway, what we were able to do for purposes of this exercise, which may be worth looking at regionally at some point, but not now, is the idea of, so Title 24, all certified law enforcement can do prisoner transports. So that's every local, every state, and DOC is authorized to do prisoner transports. Right now, everyone turns to the sheriffs and says, well, I don't know where the sheriff is, we can't do a transport. So we right now have set up a system, sort of like a phone tree, where if the sheriff can't handle it, that the sheriff will be calling our public safety emergency management division, who essentially then is allocating resources to the transport issue. So that could be local, it could be state, it could be DMV, wardens, anybody with a transport vehicle. DOC has also lent or is in the process of lending a van so that more than one or two people can be transported at a time. So that's prisoner transports to and from the facility. We have also gotten a commitment, which may be possible in most cases, but not all cases, due to security concerns, is housing these individuals who are going to be scheduled for trial in Chittenden County, or, Franklin County. So it's, so that logistical transport issue of going to different parts of the state to bring people back and then back, taking all that time for law enforcement officers, theoretically is reduced, because we will do what we can to keep people in the area. So I cannot address the local transportation issues, but I can address those other two issues. If you have any questions.
So this isn't really a question, just putting this in bigger context, that the key, transports is very important. The key is having the alleged offender in court. And I think, Aaron, you did a nice job of explaining a situation where the person was not incarcerated. We don't have a transport obligation, but we need to get that person in court. And that's where pretrial supervision comes in the pretrial services. I just want to make that comment, that's the critical part here. And I think a lot of this population is not being held, from what I understand. So it's even more important that we get that pretrial supervision and the people who are not being held. So, and I understand that that's also part of the plan.
Yeah, no, and I thought that was amazing to hear. I had not heard that specific incident in such detail, but the idea that those two, that we're making that connection, that's the kind of thing we should be figuring out and illustrating for purposes of the success or failure of the program. So I thought that was really interesting to hear.
Yeah. And in terms of success or failure of the program, the governor's office has indicated its willingness in partnership with us to try to figure out how we measure the determinants of success. We want to know outcomes as well. And as Jay Johnson acknowledged, we might not know at the end of 3 or 4 months, but we certainly, the city has a really robust data team. We certainly will be able to see those, at least the Burlington residents who come back through the Burlington Police Department. We'll be able to track that, and
20 or 30 people.
right. I mean, from that perspective, it's not impossible to track. And certainly we can access other publicly available data. We're very curious about understanding what works, what doesn't, and how we can really continue to emphasize what is working.
Tim, did you want to weigh in?
Yeah, so Tim Peters, Department of State Attorneys and Sheriffs, the waterfall of transport issues, if they arise, will start to arise in the next 2 to 3 weeks. Because the docket started last week, as you noted, so failures to appear are usually what then include a bail aspect, and they'll be detained over the weekend. Yep, and arrested, and then there'll be a court date, and they get transported. So that waterfall of transport topics, we'll know more in a month how that's played out. But I want to applaud the governor's office on, hey, we came to them and governor's council was probably straight up annoyed with me, but the amount of times I said the word transport to her. And then she said, you know what, we're gonna come up with a solution for this 3 to 4 months. And so emergency management we're really happy that there's a waterfall option. It's like a phone tree, right? And so we have the phone tree now set up, and that's so essential. We appreciate that.
But the key, if those folks are then detained, bail set, and they are then detained, that they are detained in St. Albans.
That's correct.
That's the next piece.
Or if they're in the women's facility out of
Well, yeah,
that's
but if, you know, for males, it's in St. Albans and not Newport or St. John's.
Thank you, Madam Chair. Well, speaking aside.
No problem. Anything else? Because I'm just letting you know you're between us and lunch.
No, nothing else. Thank you.
You wouldn't dare.
No, thank you for fitting me in.
Yeah, I appreciate people's patience. I'm really sorry we messed up in scheduling. We thought the best, but it didn't work. Let's take a quick lunch, and I would say we should have that here like one. I mean, I want to give time for BSCA.